This is the Ministry of Truth. I'm Gordon Comstock. Time for part 3 of Woe Unto You, Lawyers by Redell from 1939. Long out of print because it's more stuff you're not supposed to know about. Chapter 4. The law at its supremest. Quote, "We are under a constitution, but the constitution is what the judges say it is," unquote. Charles Evans Hughes. No truer words ever spoken, huh? The Supreme Court of the United States is generally rated the best court in the country, if not in the world. Its decisions are supposed to be the wisest, the most enlightened. Its members are kowtowed to as the cream of the legal profession, steeped not only in the technicalities of legal logic, but in the wondrous ways of abstract justice as well. Its powers are enormous. By the margin of a single vote, its 9 members can overturn the decisions of mayors, governors, state legislatures, presidents, congresses, and of any other judge or group of judges in the United States. Even the direct will of the people, as expressed in the Constitution, and its amendments can be brought to naught by Supreme Court, quote-unquote, interpretation of constitutional language. The 9 men in black robes hold the entire structure of the nation in the hallowed hollows of their hands. It would not, then, seem too unreasonable for any citizen to suppose that the decrees of these solons must, of course, be as impregnable to criticism or ridicule as man-made decrees can ever be. Even if it be true that the law, in the main, amounts to the manipulation of impressive, irrelevant words by a closed corporation of well-trained word jugglers, the law, as handed down from Supreme Court heights, should surely have more sense and substance to it. Even if it be true that the mass of practicing attorneys and little judges are fooling themselves and the public when they claim that the law, as they know and use it, is a logical science instead of a pseudo-scientific fraud, surely the 9 top men of the craft must leave few, if any, loopholes in their logic, and few, if any, cracks in the intellectual armor of their decisions. But if, by any chance, the solemn legal incantations of the Supreme Court itself can be shown as empty, inept, or illogical rationalizations based on nothing more substantial than big words with blurred meanings, then it would not seem too unreasonable for any citizen to suppose that the law, as a whole, is a lot of noxious nonsense. Practically all the cases that reach the Supreme Court, and reaching the Supreme Court often means going through 3 or 4 lower courts in turn over a period of years, are of one of 3 kinds. There are, first, the otherwise ordinary law cases which happen to involve people or companies from different states. An Iowa farmer makes a contract to sell his hogs to a Chicago packing house, and they get into a fight over the terms. Or a California tourist runs down a pedestrian in Mississippi. Or a New York newspaper publishes a libelous story about a Virginia gentleman, and the Virginia gentleman prefers lawyers to pistols. Ordinarily, little disputes of this nature are handled in the state courts. If the farmer had sold his hogs in Des Moines, or the careless driver had run down a fellow Pasadenan, or the newspaper had written about a Park Avenue debutante, not even the American Bar Association itself could have carried the case to the Supreme Court. But in the early days of the nation, it was supposed, and with some reason, that any state court disposing of a dispute between a local litigant and a resident of another state might tend to favor the homeboy and give the stranger a raw deal. So it was written in the Constitution that cases involving litigants from 2 or more states might be tried by the federal courts, and any case tried in the federal courts may eventually get up to the Supreme Court. Incidentally, this privilege of taking certain legal squabbles out of the hands of the state courts is all that lawyers mean when they talk gravely of, quote, invoking diversity of citizenship, unquote. When the Supreme Court deals with a case of this kind, it tosses around such abstract concepts as consideration and contributory negligence, and the rest, with the same abandon as does any other court, and it regularly purports to find the specific answer to the problem in some vague but quote-unquote controlling general principle. Yet it is perhaps unfair to examine or judge the court on the score of these cases. In the first place, they are the least important that come before the court. Furthermore, in most of these cases, the court is handicapped, although by a rule of its own making, in being bound to follow the law as laid down by the state courts in previous similar cases. In other words, the court is merely seeing to it that state law is fairly applied. It is in the other 2 kinds of cases that come before it, and these include practically all the significant and publicized decisions, that the Supreme Court is really on its own. The second kind of case that regularly reaches the court is the kind that involves some dispute about the meaning of the written laws of the United States. Now, it might seem that Congress, which has nothing else to do but write laws, should be able to set down clearly in black and white what it is ordering done or not done, so that the services of a court would not be needed to tell people what the laws mean. But the first catch is that these statutes are always phrased by lawyers, in Congress or out, so that it frequently does require the services of other lawyers to disentangle the meaning from the verbiage. And when the other lawyers disagree, as they are sure to do if there are fees on both sides of the dispute, then it takes a court, and it may take the Supreme Court, to tell the second group of lawyers what the first group of lawyers meant when they wrote the statute. There is, moreover, another catch, and it was referred to a couple of chapters back. Even when the words of a statute appear, at least to a non-lawyer, to have a perfectly plain and definite meaning, you can never be sure that a court will not up and say that those words mean something entirely different. The Supreme Court is no exception. There was the time it said that Section 20 of the Clayton Act meant literally nothing at all. There was the time the court ruled that the clause of the Guffey-Cole Act directing that if part of the act be declared unconstitutional, the rest of the act should go into effect anyway, meant the exact opposite of what the clause said. And there have been countless other examples of meaning mangling when the court has undertaken to, quote-unquote, interpret the statutes of the United States. For instance, when Congress first passed an estate tax taxing the transfer of money or other property at death, which violates God's law and will, rich men rushed to their lawyers to find out how they could get around the tax without giving away their wealth before they died. By the way, the estate tax, that's just further proof that the United States is still a British colony. Again, read the works of James Montgomery at atgpress.com, againstthegrainpress.com. Click on Knowledge is Freedom. It's the King of England, and above him it's the barristers of England, and above them it's the Crown of England who are taxing estates, because you can't really own land in America. Only the king, only the crown above him, the group of bankers in London, owns all of our land. And above them is, ding, 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 the Vatican. Sorry, folks, that's the way it is. Getting back to the book. The commonest and, by and large, the most effective dodge consisted and used was for the rich man to put his property in trust, which of course only meant giving the property to someone else to keep for him by the use of the proper legal rigmarole, and still to keep several strings on the property himself. He might keep the right to take the property back any time he wanted it. He might give up his right, but insist on getting the income from the property, which was usually stocks and bonds, as long as he lived. He might keep the right to direct the management of the property, or to say who should get it at his death. At any rate, the idea was that since he no longer, quote-unquote, owned the property legally, parentheses, legally, the trustee, quote-unquote, owned it for him, end parentheses, he couldn't be taxed for giving it to his wife or his children at his death, even though that might be exactly what he had ordered the trustee to do. But Congress, foreseeing some such subterfuge from the start, had written into the estate tax law, in legal but comparatively comprehensive language, a special provision. The provision was that any transfer of property, even though not done in the usual way of making a will, which was, quote, intended to take effect in possession or enjoyment at death, end quote, should be soaked under the estate tax. And very soon the question arose, and was carried up to the Supreme Court, whether an estate tax had to be paid on property that a man had put in trust, ordering the trustee to pay him the income as long as he lived, and then turn over the property to his son at his death. Certainly, this would seem to be one of the exact situations that Congress had been talking about. The man kept right on enjoying his interest and his dividends until he died. The son was not even privileged to smell the stocks and bonds until, at his father's death, they were turned over to him. From his standpoint, it was then, and not until then, that his, quote, possession and enjoyment, unquote, of the property, quote, took effect, unquote. Not at all, said the Supreme Court in substance, when it was asked to, quote-unquote, interpret and apply the statute. In the first place, we have a general principle to the effect that tax statutes are to be strictly construed in favor of the taxpayer. True, we also have a general principle of statutory construction to the effect that words are to be read in the light of their customary and accepted meaning. Parenthesis, presumably the court did not care to deny that enjoyment meant enjoyment, end parenthesis. But the prior principle seems here to carry more weight. The fact that various state courts have interpreted identical words in their state death tax statutes so as to cover the type of transfer here at issue, the state courts had, almost unanimously, is not controlling upon us, i.e., the Supreme Court. Finally, there is the compelling fact that the decedent, i.e., the dead man, had completely divested himself of title to the property before his death. Parenthesis, indeed he had, according to the law, but Congress had said nothing about legal title. It was the taking effect of enjoyment that was supposed to matter, end parenthesis. At any rate, concluded the 9 Solons, the Dodge works. The statute doesn't cover this case. No tax. The payoff came the very day after the decision was handed down. On that day, Congress amended the statute so that the estate tax, even more specifically, applied to transfers of property in which the original owner hung on to the income for himself until his death. Of course, a couple of tax lawyers hopefully asked the Supreme Court to rule that, under certain circumstances at least, this didn't mean what it said either. But this time the court upheld the tax. This time the second principle of statutory construction, as outlined above, outweighed the first principle. For yet another example of Supreme Court interpretation of written laws, take the old congressional statute still on the books, which says that collection of federal taxes may not be enjoyed, quote-unquote, in any court. A legal injunction being, of course, no more than a court order forbidding someone from doing something. The idea, whether wise or unwise, was to keep innumerable injunction suits from holding up the collection of federal revenues. If a man or a company thought a tax was too big or too raw or just plain illegal, he was supposed to pay it anyway and then sue to get it back. Certainly the statute itself was and is so short, blunt, and simple that no sensible person, no non-lawyer, could possibly miss its meaning. But, strangely enough, the commonest way of protesting a new federal law today is to sue for an injunction. The Supreme Court, in the course of interpreting the statute in the light of general principles of law, has so cluttered it with exceptions that the exceptions all but blot out the statute. Examples could be multiplied almost indefinitely. For when the Supreme Court sets out to tell Congress and the world what an act of Congress really means, only the sky and such abstract legal principles as can be drawn from the sky are the limit. And all that Congress can do after such an interpretation is patiently to amend or rewrite the statute with the fervent hope that maybe this time the words used will mean the same thing to the Supreme Court that they mean to Congress. But in the third kind of case that takes up the time of the Supreme Court, there is no getting around afterward what the court has decided. There is no getting around the decisions, that is, short of amending the Constitution, changing the judges who make up the court, or, most difficult of all, changing the judges' minds. The third kind of case, the most important of all, includes all those disputes in which someone claims that a state law or a federal law or some action taken under such a law, quote-unquote, offends the U.S. Constitution. Here, the Supreme Court is the final word. What it decides and what it says in these cases make up that holy hunk of the law known as constitutional law. From the practical or non-legal viewpoint, constitutional law adds up simply to a list of all those instances where the Supreme Court has said to Congress or to a state legislature, quote, you may not enforce that statute, unquote, or where it has said to a federal or state executive officer or administrative board, quote, you may not carry out that ruling, unquote. The instances where the court has said, you may, don't count. From a practical viewpoint, there, the situation would have remained exactly the same as if the Supreme Court had never said anything. And it is worth noticing that only governments or people who are performing government jobs ever get spanked by the court for being unconstitutional. The Constitution protects, within certain limits, free speech. But a man who holds his hand over another man's mouth to keep him quiet, though he may get hauled into court for minor assault and battery, will never get charged with violation of the Constitution. Thus, what constitutional law deals with is the restrictions on certain forms of government action which are laid down in the name of the Constitution by the Supreme Court, which is, although many people are prone to forget this, no more than one branch of the federal government itself. And all that constitutional law, taking it in the more legal sense, amounts to, is the cumulative efforts of the Supreme Court to explain, justify, or excuse the restrictions it lays down. Now, the basic theory of all constitutional law is both simple and sensible. It is that if Congress or any state or city or village enacts a law that is forbidden by the Constitution, that law might just as well never have been enacted. It can be ignored. It is no good. It is unconstitutional. But the fireworks start when it comes down to a question of who is going to tell whether laws are unconstitutional and how. For the Constitution itself, as is little realized, nowhere gives that right to the Supreme Court. The Supreme Court early assumed that right, so far as state laws were concerned, and nobody objected much because neither Congress nor the President wanted to bother to check up on state laws. But the Supreme Court was much more cautious when it came to telling Congress and the President that federal laws were unconstitutional. Only once in more than 60 years after the birth of the nation did the court dare to peep that it thought an act of Congress was improper, and the habit of informing the other two branches of the government that some measure they had approved was downright illegal never really blossomed into full flower until the 20th century. It is still at least arguable that Congress or the President or the two of them together have as much right and as much ability to decide whether a proposed federal statute disobeys the Constitution or not, as have the 9 bold men. Yet, granting that by custom, if by nothing more, the last word does belong to the Supreme Court, the question remains, how, and how well, has the Court exercised this powerful privilege, as applied to the laws of the states as well as to those of the nation? Have its constitutional decisions been models of logic, statesmanship, and justice, or have they perhaps been cut out of the same old legal cheesecloth, abstract concepts, ambiguous words, and ambidextrous principles? There are some parts of the Constitution that are written in such plain language that nobody, not even a lawyer, could very well mistake what they mean. There is, for instance, the provision that the United States shall not grant titles of nobility. There is the provision that each senator's term... This is an irony I didn't pick up the first time I read this book. Boy, if Fred Redell could just have known what James Montgomery found out. The titles of nobility, every lawyer has a title of nobility. It's called an esquire, and it derives, making them subordinate subjects of the King of England, whether they know it or not. Most lawyers, of course, don't. The high elite do. And all American lawyers are subject to the British barrister. This, they don't know it. Nearly all of them don't know. But James Montgomery and the Informer at ATG Press proved it. So, Fred Redell, oh boy, you must be rolling in your grave at that one. So even the lawyers could twist that one around. Even they could hide behind it with their own little titles of nobility themselves, naturally, of course. All right, getting back. There is the provision that each senator's term shall be for 6 years. There is the provision that the states shall not coin money. Obviously, if Congress had voted to make Charles Lindbergh a duke instead of an army colonel, or if a federal statute were passed extending all senators' terms to 8 years, or if the Oklahoma legislature were to enact a bill to set up a state mint and start turning out silver dollars, any of those laws would be clearly unconstitutional. But it would scarcely be necessary to ask the advice of the Supreme Court on such matters. Any submoron could give the right answer. There are other parts of the Constitution that are not written so plainly. It may be that they use hazy legal words, or it may be that the words they use, though fairly clear at the time of writing, have since acquired a nebulous quality through constant legal mastication of their meaning. It is out of these parts of the Constitution, and for that matter, out of parts that are nowhere in the document at all, that constitutional law is really built. Whenever a lawyer appears before the Supreme Court and asks the court to declare a state statute unconstitutional, the chances are better than 10 to 1 that he is basing his plea on the 14th Amendment to the Constitution. The chances are almost as good that he is basing his plea on one little clause out of one of the 5 sections of the longest of all amendments. Good old 14th slavery, is enslaving both whites and blacks amendment. Turning us all into federal citizen slaves, that 14th Amendment. The chances are, in short, that he is claiming that, by the statute in question, his client has been, quote-unquote, deprived of property without due process of law. For most of constitutional law, as applied to state statutes, and as laid down by the Supreme Court, revolves around that little phrase. On the basis of that phrase alone, The court has killed hundreds upon hundreds of state attempts to regulate or tax business and businessmen. As a matter of fact, it is practically impossible for a state to pass such a statute today without having a legal howl carried to the Supreme Court to the effect that the statute, quote, violates the due process clause of the 14th Amendment, unquote. What then, according to its official interpreter, does the little clause mean? When is a deprivation of property not a deprivation of property? Surely every tax is, in a sense, a deprivation of property, and some state taxes are perfectly legal. And what is implied by that lovely limpid legalism, quote, due process of law, unquote? To help it answer these questions, the Supreme Court has evolved, and this will be a big surprise, a batch of general principles. There is the general principle that a regulation which is proper exercise of the state police power is valid, but that a regulation which does not fall within the police power is deprivation of property without due process of law. There is the general principle that businesses affected with a public interest may, by and large, be regulated, but that to regulate a business not so affected is a D-O-P-W-D-P-O-L. There is the GP, that a tax on anything over which the state has jurisdiction is proper, but that a tax on something over which the state has no jurisdiction is a DOP, etc., and so on. Of course, just what state police power is, and just what a business affected with a public interest amounts to, and just what state jurisdiction to tax means, is, in each case, another and longer story. There are sub-principles and sub-sub-principles and exceptions. And, of course, too, there is not a word in the Constitution about police power or businesses affected with a public interest or state jurisdiction to tax. But this fact does not stop the Supreme Court from using such concepts as the basis of constitutional law. Even the highest court of the land, laying down the supreme law of the land, reverts to the same old hocus-pocus of solemn words spoken with a straight face and meaning intrinsically nothing. If this indictment sounds too strong, consider what a member of the court once had to say about the uses to which his brethren put that little clause of the 14th Amendment. These are the words of the late Justice Holmes. Quote, I have not yet adequately expressed the more than anxiety that I feel at the ever-increasing scope given to the 14th Amendment in cutting down what I believe to be the constitutional rights of the states. As the decisions now stand, I see hardly any limit but the sky to invalidating those rights if they happen to strike a majority of this court, as for any reason undesirable. Of course, the words due process of law, if taken in their literal meaning, have no application to this case. We should be slow to construe the clause in the 14th Amendment as committing to the court, with no guide but the court's own discretion, the validity of whatever laws the states may pass, unquote. Justice Holmes' brief warning about the temptation to follow personal preferences where the law is so amorphous and indeterminate was spoken, as usual, in dissent. But what did he imply by his reference to the words due process of law if taken in their literal meaning. What did that little clause of the 14th Amendment, since inflated by the Supreme Court to tremendous significance, originally mean? It makes an interesting story. The 14th Amendment was one of 3 amendments added to the Constitution shortly after the Civil War to protect the civil rights of the Negroes. The first of its 5 sections include the command, presumably intended to prevent persecution of the ex-slaves, quote, "Nor shall any state deprive any person of life, liberty, or property without due process of law," unquote. But the words used in that clause had appeared in the Constitution before. They had appeared in the 5th Amendment as part of the original Bill of Rights. There, 77 years before the 14th Amendment was adopted, it was decreed, quote, "Nor shall any person be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law," unquote. Because the 5th Amendment was said to restrict only the federal government, it was felt necessary to place the same restriction on the states in the 14th. What then was the quote-unquote due process business intended to mean? How did it happen to have been coupled with the prohibition against making a man take the stand against himself in a criminal trial? It was no accident, for quote-unquote due process, before the Supreme Court began to build general principles around it, meant nothing more complicated than, quote, proper procedure, unquote. And being deprived of life, liberty, or property without due process of law meant only being hanged, deprived of life, jailed, deprived of liberty, or fined, deprived of property, without a proper trial. Thus, the due process clause was originally intended to apply only to criminal cases. The idea that any statute, much less a non-criminal one, like a tax or a regulation of business, after being properly passed by a legislature, signed by a governor, and enforced according to its terms by judges, could amount to a deprivation of anything without due process of law, would once have been laughed out of court. Yet the Supreme Court has built the bulk of its constitutional law, as applied to the states, on precisely that strange supposition. It has taken a simple phrase of the Constitution, which originally had a plain and precise meaning, twisted that phrase and those principles as excuses for throwing out or majestically upholding state laws. Nor should it be supposed that the silly house of cards logic of constitutional law works only in what might be called unprogressive ways. True, most of the state statutes the Supreme Court has condemned as quote-unquote violating the quote-unquote due process clause of the 14th Amendment have been such measures as minimum wage laws, laws protecting labor union activities, laws and rulings setting public utility rates, certain types and uses of income and inheritance taxes, and other restrictions on the business of making money and keeping it. But as mentioned before, the word magic of legal processes recognizes no socially significant limitations. Constitutional law can be just as illogical and irrelevant on the liberal side. There are, for instance, as few people are aware, no words anywhere in the Constitution protecting freedom of speech, freedom of the press, freedom of religion, or freedom of assembly against infringement by the states. The sole reference to these civil liberties in the whole Constitution is in the First Amendment. All that the First Amendment says is that, quote, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances, unquote. Yet, as almost everyone is aware, the Supreme Court has, on occasion, protected civil liberties against infringement by state law or by city ordinances, parenthesis, cities being considered legally as mere subdivisions of states, subject to the same constitutional taboos, end parentheses. Huey Long's attempt to gag the opposition press under a Louisiana statute was called unconstitutional by the court. Well, sure, FDR stacked the court, and so they're going to go against Huey Long, who was a threat to FDR. Of course, that was going to happen. So were Mayor Haig's efforts to clamp down on freedom of speech under a Jersey City ordinance. Why unconstitutional? Inasmuch as it was surely not Congress that passed either of these measures? The answer lies once more in the well-worn Due Process Clause of the 14th Amendment. Laws such as these, said the court, deprive people of liberty without due process of law. A worthy sentiment, unquestionably, but just as illogical and just as unwarranted by the true meaning of the constitutional phrase as all the other and less popular due process decisions. There is, moreover, a clear danger in leaving the protection of civil liberties against state infringement to the whims and general principles and legal logic of the Supreme Court. Instead of writing it into the Constitution, as should have been done long ago, a broad and definite protection of those liberties against all infringement. For just as the court has held that some state restrictions of freedom of speech and the rest are bad, under the Due Process Clause, so it can hold and has held that other restrictions are not outlawed by the 14th Amendment. Where the logic of the legal rule is so tenuous, the court can blow now hot, now cold. As is true of practically all constitutional law, it is impossible to tell what the court is going to call unconstitutional until the court has gone into its trance and evoked a spirit in the shape of a quote-unquote controlling principle. Though the bulk of constitutional law, as applied to the states, stems in a mystic manner from the Due Process Clause of the 14th Amendment, its parent clause in the 5th Amendment has not been used or needed so often as an excuse for calling federal laws unconstitutional. Railway workers were doubtless interested to learn that the congressional outlawing of yellow dog contracts, i.e. contracts forbidding membership in a labor union, deprived the railroad companies of liberty and property without due process of law. Women who worked in Washington, D.C. were doubtless fascinated to hear that their employers had been similarly deprived by a congressional act setting minimum wages for women. Both the railway men and the Washington women were probably especially impressed to be told by the Supreme Court that anti-union discrimination and sweatshop wages were protected against congressional interference by none other than the American Bill of Rights, of which the Fifth Amendment is, of course, a part. But the Supreme Court's pet reason for calling federal laws unconstitutional is even more complicated than the due process gag, and even harder to trace back to the Constitution itself. The general idea is that the federal government may not do anything that the Constitution does not specifically say it may do. This notion is what is known as, quote, strict construction of the Constitution, unquote. And it is all mixed up with the slogan of, quote-unquote, states' rights, which is a very nice and very handy political slogan for those who do not like what the federal government happens to be doing at the moment. The chief reasons usually given by the Supreme Court for backing the strict construction principle instead of the contradictory loose construction or let the federal government do anything the Constitution doesn't say it may not do principle are two in number. The first reason is that the Founding Fathers in person were strict constructionists and intended to hog-tie the federal government when they wrote the Constitution, but that, as every historian knows, is utter nonsense. The Founding Fathers, almost to a man, avowed enemies of states' rights, were out to give the federal government all the rope they could possibly give it. How's that? Still, as the present uses of the due process clauses indicate, a little matter like historical inaccuracy is never allowed to interfere with a general principle of law. The second reason the court gives for its zealous protection of states' rights is the Constitution's 10th Amendment. Parenthesis, those amendments begin to look more important than the whole original Constitution, and to any of the legal tribe they are. End parenthesis. What the 10th Amendment says is, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. So far, so good. But the question remains, what powers are delegated to the United States by the Constitution? And it is in answering that question, which is left hanging in mid-air by the 10th Amendment, and which is more confused than clarified by the rest of the Constitution, that the court has so often performed back somersaults of logic right into the camp of the strictest strict constructionists, all, of course, in the name of the law and the Founding Fathers. There is, for instance, a clause of the Constitution, the original Constitution for a change, to the effect that, quote, the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the general welfare of the United States, unquote. Lawyers and law professors and judges have written tracts and treatises and whole books about the meaning of this clause. The strict construction boys say it means that Congress can collect taxes, etc., in order to pay the debts and provide for the general welfare of the people. The loose construction boys say it means that Congress can collect taxes and also pay debts, and also, with laws that aren't necessarily tax laws, provide for the general welfare. You can guess which side the Supreme Court is on. Why? Why, because that's what the Founding Fathers meant which, as a matter of historical record, they almost surely didn't. And because of the 10th Amendment, which obviously has nothing whatsoever to do with the case. It was on a line of so-called reasoning of this sort, only more extreme, that the Supreme Court threw out the original Agricultural Adjustment Act, and this despite the fact that Congress, well aware that the court would only let it provide for the general welfare in tax statutes, had passed the act as a tax on farm products, the proceeds to go as bounties to those farmers who cut down the acreage of their crops. Now, many people thought the AAA unwise and rejoiced at the Supreme Court decision. But even they would admit that it is certainly not the job nor the right of the Supreme Court to judge the wisdom or the foolishness of laws. That, supposedly, is Congress's business. The court, as it has proclaimed countless times, can only decide whether a law is constitutional. Here is why, according to the Supreme Court, the AAA was unconstitutional. It used federal tax money to accomplish an unconstitutional purpose. What was that? Federal regulation of farmers. Why is federal regulation of farmers unconstitutional? Because regulation of farmers is exclusively the right of the states. Why? Because of the general principle that the federal government is a government of limited powers, i.e., strict construction. Because of the Founding Fathers, parentheses, yes, end parentheses, and specifically because the 10th Amendment reserves to the states those powers not delegated to the federal government. Well, isn't one of the powers delegated to the federal government the power to collect taxes and obviously spend them to promote the general welfare? Granted. Then why isn't the AAA, whether you like it or not, an exercise of that power? Or do you mean that giving bounties to certain farmers does not, in your judgment, promote the general welfare? No, said the court, we are not now required to ascertain the scope of the phrase general welfare of the United States, or to determine whether an appropriation in aid of agriculture falls within it. Then why in heaven's name isn't the AAA perfectly constitutional as a tax to promote the general welfare, which you grant Congress the right to enact? Because it uses the tax money to accomplish an unconstitutional purpose, namely federal regulation of farmers. And there sat the Supreme Court at the end of its opinion, exactly where it had started, after one of the most perfect examples of arguing in a circle that any court has ever indulged in. But plenty of long words and solemn spoken principles of law gave this circular reasoning an air of depth and respectability. After all, the court was only patiently explaining that the Constitution clearly forbade Congress to enact the AAA. Any lawyer, at least, would understand. Another power given to the federal government by the Constitution is the power to regulate interstate commerce. Because that power is granted, very specifically and plainly, many of the most important federal statutes are fashioned around it. But you can't get by the Supreme Court that easily when the court is out to lay down constitutional law. When Congress tried to discourage child labor by forbidding the shipment of things made by child labor in interstate commerce, the court calmly said, "This is no regulation of interstate commerce. It's just a nasty old invasion of states' rights, and it's unconstitutional." There were, of course, general principles which, quote-unquote, controlled. When Congress then put a high tax on child labor, figuring that it still retained the power to levy taxes at least, the court said, "This is no tax. It's a regulation, and it's still unconstitutional." In so saying, the court conveniently ignored the fact that it had previously let Congress, by exactly the same device of a high tax, put an effective stop to the issuance of state banknotes and to the sale of yellow oleomargarine, which was passed off as butter, and to the interstate shipment of opium and other narcotics. In those cases, presumably, the controlling principles were different. It is, moreover, worth noticing, as indicating the tremendous power of those 9 anointed lawyers, that, despite efforts to amend the Constitution, child labor still flourishes in this country more than 20 years later, just because the court once said that the Constitution protects the sacred right to employ child labor against any nefarious attempts by Congress to interfere with that right. And similarly, it took almost 20 years before the Constitution was amended to allow a federal income tax, after the court had solemnly figured out, through a series of abstractions too involved to be recounted here, that the original Constitution forbade Congress to tax citizens' incomes. It was under the court's, quote-unquote, interpretation of what the Interstate Commerce Clause did not mean that such New Deal laws as the National Industrial Recovery Act and the Guffey Coal Act met their death. It seems there are 2 principles. One is that Congress may regulate anything that affects interstate commerce directly. The other is that Congress may not regulate anything that affects interstate commerce only indirectly. Of course, there is not a word in the Constitution itself about direct or indirect effects on interstate commerce, but that does not keep those effects from being a very vital consideration in constitutional law. Applying these principles, the court said that working conditions in companies doing interstate business affected interstate commerce only indirectly. So it was perfectly apparent that the NIRA and the Guffey Coal Act, both of which made bold to regulate those working conditions, were downright unconstitutional. But by the time the Wagner Labor Act came along a couple of years later, working conditions in companies doing interstate business had suddenly acquired a direct effect on interstate commerce, and so a law regulating those conditions was perfectly constitutional. The relevant principles of constitutional law remained, of course, unchanged. It was merely that, this time, a different principle was controlling. There was, moreover, a second reason why the NIRA was unconstitutional, for the court is not always content to kill a law with one shot of constitutional principle. The second principle is especially interesting because it involves one of those chunks of constitutional law that is not even remotely derived from anything written in the document that most people think of as the Constitution. The court just made this up all by itself. The basic principle that the court made up is that Congress may not delegate or hand over any of its law-making power to anyone else. Now, it is clear that if this principle were really followed, there wouldn't be any United States government. All the thousands of rules and regulations and orders, little laws, every one of them, that are formulated day after day by every branch of the government, by the commissions, like the Interstate Commerce Commission and the Federal Trade Commission, by the departments, all 10 of them, and by the branches and bureaus of the departments, like the Patent Office and the Coast Guard and the rest, all these rules and regulations would have to be passed by Congress itself. It is only because Congress has always delegated the largest part of its lawmaking power, after laying down the broad general outlines of a law, that the federal government has been able to function at all. But the Supreme Court, as might be expected, has an answer to all this. It is in the form of a sub-principle, or exception to the primary principle. It is that Congress may delegate to other people the power to fill in the details of a law, but not the power really to make a law. That lets out all the commissions and the departments and the rest, and doubtless lets Congress breathe a lot easier. But when the NIRA came up for review, despite the fact that Congress had certainly passed the law and, as usual, filled numerous pages with its written provisions, the court said Congress was handing over its law-making power to the keepers of the Blue Eagle. Why the Recovery Administration was really making laws, whereas the National Labor Board, for instance, is merely filling details, only the Supreme Court knows, and it won't tell. It is much too busy expounding constitutional law. Perhaps the best known of those pieces of the highest law of the land that the court has manufactured out of ethereal logic with no help at all from the words of the document is the piece that deals with the federal government taxing the state governments and vice versa. It all started with Chief Justice Marshall's famous bromide that, quote, "the power to tax involves the power to destroy," unquote. Therefore, argued Marshall, with his court chiming in, we can't have the states laying taxes on the property or the activities or the bonds or the employees of the federal government, and we can't have the federal government levying taxes on the states either. For if we allowed such taxes, one of our governments might insidiously destroy the other. Even if there isn't anything about it in the Constitution, such taxes are unconstitutional as a matter of principle. It developed, as it always does, that there were sub-principles. The court discovered one to the effect that the federal government, while it could not tax the quote-unquote governmental functions of the state governments, could tax the quote-unquote non-governmental functions of the state governments, which may sound confusing to a non-lawyer in that it is hard to think of something done by a government being non-governmental, but which was perfectly clear to the Supreme Court. Also, while a quote-unquote direct tax levied by a state on something connected with the federal government was all wrong, an quote-unquote indirect tax was all right. Now, for some reason, wrung from the metaphysical reaches of constitutional law, the court considers an inheritance tax an quote-unquote indirect tax. Therefore, any state can slap on a tax when a man dies and leaves his federal bonds to his wife. But since an income tax is a quote-unquote direct tax, no state can tax the man, or his wife either, on the income he makes from those federal bonds. Presumably, going back to the primary principle, such a tax might destroy the federal government. the corresponding immunity of state bonds from the federal income tax raises yet another question. Can you necessarily change the Supreme Court's notions about constitutional law even by amending the Constitution? Apparently not, for the income tax amendment gave Congress the power to tax incomes, quote, from whatever source derived, unquote. The words could scarcely be plainer or stronger, and part of the reason for writing them in was to put an end to the immunity rule so far as the federal income tax was concerned. But the court still says that it is unconstitutional for the federal government to tax the income from state bonds. Thus, the unwritten piece of the Constitution that the court discovered all by itself carries more weight with the court than the written words of the document. Finally, there was the time the court was called upon to decide the delicate question whether the salaries of federal judges could be taxed under the federal income tax. The judges were not part of any state government, so they could not come in under the mutual immunity rule. But there was another opening. The Constitution says that the salaries of federal judges may not be reduced while the judges are in office. Aha, said the court. To make us pay an income tax on our salaries the way everybody else does would clearly be just the same thing as making us take a salary cut. And that, obviously, would be unconstitutional. Of course, there was still that little phrase in the amendment about incomes, quote, from whatever source derived, unquote. But by a strange reversal of customary reasoning, the court seemed to feel that the old no salary cuts clause amended the amendment instead of vice versa. Again, doubtless a matter of principle, you hypocrites, exempting yourselves from your own laws. So runs in brief the story of how constitutional law, the highest law of the land, is laid down by the Supreme Court of the land. Here is the law at its best. Here are the lawyers at their most distinguished, their most powerful, still comparing piles of abstract, indecisive, and largely irrelevant principles as though they were matching pennies on a street corner, still draping in the longiloquent language of a generalized logic the answers, some good, some bad, to specific social problems, and purporting all the while to be applying the commands and prohibitions of the U.S. Constitution. No wonder Charles Evans Hughes, long before he became the Supreme Court's Chief Justice, once blurted out with a bluntness that is rare in lawyers, quote, "We are under a Constitution, but the Constitution is what the judges say it is," unquote. And of course the judges themselves, as could scarcely fail to occur when the rules of the game are so vague, are forever disagreeing about what the Constitution is. Every man on the street has heard of 5-4 decisions and dissenting opinions. But a dissenting opinion, though it may make its author feel a lot better for having written it, is in essence no more than a critical and occasionally literary essay. What is said by the 5 or 6 or 7 or 8 justices who voted the other way is the law. It is just as much the law, so far as that case is concerned, as if the decision had been unanimous. Thus it can happen, and has often happened, that one man, one judge, holds the quote-unquote meaning of the Constitution in his hands. This possibility was never more strikingly illustrated than when, less than a year after the court called a New York minimum wage law for women unconstitutional, It called a Washington state minimum law for women constitutional, all because one man, Justice Roberts, voted on the other side. It seems that the New York statute deprived employers of their property without due process of law, and therefore violated the 14th Amendment, whereas the almost identical Washington statute was a proper exercise of the state police power and therefore didn't violate anything. Of course, it was not the principles, the basic law, that changed with Justice Roberts' mind. It was merely that in one case, one principle was controlling. In the other case, it gave way to a different principle. And it is worth repeating and remembering that the alleged logic of constitutional law is equally amorphous, equally unconvincing, equally silly, whether the decisions the court is handing down are good or bad, progressive or reactionary, liberal or illiberal. The principles under which the Washington minimum wage statute was blessed had no more to do with the problem or with the Constitution than those under which the New York minimum wage statute was damned. The Wagner Labor Act was called constitutional for no more solid reasons than those for which the Agricultural Adjustment Act was called unconstitutional. Freedom of the press in Louisiana was defended by logic no less far-fetched than that which upheld the freedom to employ child labor. No matter in which direction the legal wand is waved, the hocus-pocus remains the same. There is one more principle of constitutional law that is worth mentioning, although it has been rather sadly neglected. It is that any law, state or federal, is entirely proper and valid unless clearly and unmistakably forbidden by the words of the Constitution. But then, if this principle were regularly followed, there would not be much use for any of the other principles. There would not be much constitutional law either. Okay, folks. That was part 3 of Woe Unto You, Lawyers by Fred Redell from 1939, out of print. Why? I'm Gordon Comstock. This has been the Ministry of Truth.